You can't try every case. It's just not possible.
If every case was taken to trial, it would just be an incredible tax on the system.
Major court players agree that the education of the general public on the inner workings of court proceedings is a necessary component to understanding how plea agreements work. Judges and attorneys alike find the use of plea agreements to be an essential key to the entirety of the criminal justice system. There are a plethora of reasons as to why plea agreements are so widely used and appreciated by all entities within the court. For one, it helps alleviate the number of cases in the system.
I just look at the district court filings alone last year, and I think we had approximately 1,400 criminal filings that we handled. Can you imagine if every one of those went to trial?
We just don't have the judges, the time, the resources. We'd have people sitting in the hallways subpoenaed. We'd have police officers subpoenaed sitting in the hallways. We'd have citizens called in waiting to be called to a jury, and cases would not get processed in a timely fashion at all.
In addition, the use of plea agreements removes the uncertainty of going to trial.
I think it's sometimes a significant gamble. There's a lot of unknown in the court process, and so the ability to have faster resolution with certainty for all the participants is an advantage that a lot of people see in the process.
A jury trial is a risk for both sides. You don't know what's going to happen. You're entrusting the resolution of the case to 12 people who've never met you before, who've never seen the case before, who have no knowledge of the case. Whereas if we negotiate a plea agreement, we can, to some extent, then help control what the outcome is.
There's real consequences for going to trial. A defendant could get a much harsher outcome or sentence if he or she decides to roll the dice and go to trial on more serious charges when there's an opportunity to plead guilty to a lesser charge.
While there are benefits for using plea agreements, there are a few harsh realities that create drawbacks to the system.
I have to believe that some people are pleading guilty in a plea agreement to something they're not guilty of because they're too concerned about what the consequences might be if they go to trial.
Sometimes people feel as if plea agreements give kind of pressure on a defendant to say, maybe I better take this because if I go to trial, I might get found, I might get found guilty. So, I mean, there certainly are negatives and positives, and I think the same can be said with the jury trial process too.
There are two possible types of plea agreements that can be reached in a case. A charge bargain is a reduction of charges, whereas a sentence bargain is a reduction in time served. There's also an option for first-time youthful offenders. If a defendant is deemed eligible, they may qualify for probation under the Holmes Youthful Trainee Act. If they comply with the terms of their probation, the incident is expunged from their record. And those being prosecuted for drug crimes may also advance to drug courts in which they seek treatment for their addiction. Everything is decided on a case-by-case basis. Either way you cut it, the sentencing is ultimately the judge's call. There are clear cases in which both sides know a case will most likely go to trial. In some cases, the accused is asserting innocence and won't consider pleading out. In other cases, the crime is so horrific the prosecutor will not budge for any leniency.
In a perfect world, people wouldn't break the law and we wouldn't need our system. We don't have that. In a less perfect world, we would have enough resources to handle every case the same way, but we don't.
Reporting from Marquette for ABC 10 and the CW5, I'm Chelsea Birdsall.